Part two of today's Local 6 Legal Line with some of the attorneys from the Bryant Law Center, Paducah, Mayfield, and Louisville. I got to introduce them earlier. It's Austin Kennedy and Kevin Shannon. Gee, where's my mind at today? Well, next question we have in this segment of Legal Line. Someone says, I was in an accident driving my work truck loaded with all my construction tools. Many of those tools were damaged. Now, shouldn't the insurance company also pay for the tools in addition to the damage to my vehicle?
Yeah, Dave, I'll take that one, and the answer is yes. Assuming the tools are damaged, that would properly be a part of the property damage claim. Sometimes you have a difficult time establishing the value of the tools, and there are lots of factors that go into it, but if you've had the accident, the tools are still available, you'll need to document exactly what tools are there. Try to document the damage to them either through photographs or otherwise, and then you need to go ahead and try to establish a value for those tools. So, but if you're able to put the proof together, you should get compensated for the loss of your tools or to replace them.
Next question comes from someone who evidently was in an accident, and they say that the insurance company keeps calling them, asking them to get the claim settled. And this person wants to know, can I settle just the property side of it and wait on the medical side of it? And I'm guessing at that point, you probably need to know what you're signing.
For sure, no, and that would be preferable. You know, usually with the property damage, you want to get that over with as soon as possible. It's not going to get any better by waiting on it. Try to come up with a fair estimate to get it. You can do the research yourself. Look at Kelley Blue Book or National Highway Safety. Try to find the value of that vehicle. You can make an offer yourself or ask the auto carrier to make you an offer. But to get that done, relatively quickly. As with the injury part of the case, I mean, obviously that's going to be dependent on when you finish the medical treatment. You don't want to just jump into that and settle that when your medical treatment's still ongoing. So, typically with the property damage, you're only going to sign a document that just exclusively deals with the property, but I would make sure you look over that very closely so you're not waiving any claims for any personal injury or bodily injury that you may have.
Next question comes from someone who says this person has a hernia mesh. All of the doctors he's seen will not operate on the man. Does he have a case?
I'll take that one. It's possible. There are a lot of hernia mesh cases out there. I think it'll depend in large part on the exact mesh that you had placed in your body. All of those things have to be documented, so even if the surgery where you had the mesh implanted was years ago, your medical records should specifically identify what product was put inside your body. If that mesh was then subject to a later recall or some kind of product liability claims process, then you would have a claim. You need to do something about it sooner as opposed to later, though. Don't wait.
Kevin Shannon, Austin Kennedy, attorneys from the Bryant Law Center, Paducah, Mayfield, and Louisville. Our guest today on Local 6 Legal Line. Want to review either one of these segments? You can do so shortly. They'll be online at WPSDLocal6.com.